Okay, let's get started on the topic of reasoning with rights. For to talk about reasoning with rights, it's good to first talk about reasoning generally. And to talk about reasoning generally, it's a good idea to begin with the concept of a reason. Reasons are considerations that are in favor or against something else. That is to say that reasons are facts that count in favor of against some other fact. This is very abstract, but an example makes it very clear. That it's raining is a reason to bring an umbrella. Reasons therefore have polarity. They can be in favor or against something. In this example, the case that it's raining is a reason in favor of bringing the umbrella, but you could also say that it's very windy is a reason against bringing an umbrella, because if it's very windy, your umbrella will be of no use and you will end up actually just with a damaged umbrella and just as wet. Then we can say that the process of reasoning is taking those reasons that you have and moving from the reasons that you have at first glance to what's called an ATC judgment or an all things considered judgment. So you weight the value of the different reasons you have, and then you say, well, this is what I will do in the end. I will bring my umbrella, or I will not bring my umbrella. And then we can see this very first diagram, and it's just very easy. You can imagine reasons as vectors of force pulling you in different directions. And moving into an ATC judgment would be finding whether reason one, that it's raining, is stronger than reason two, that it's really windy, for the conclusion of bringing or not bringing an umbrella. On top of this first order reasons, so we can call these reasons first order reasons, reasons that directly impinge on a conclusion about doing something or believing something. On top of that, we can speak of second order reasons. So the normal role of reasons is, to be in favor or against, to contribute in favor or against a particular conclusion. But you would also have a second layer of reasons that just apply to your other first order reasons. So they're second order reasons. And you could class these types of reasons into two grounds: underminers and defeaters. An underminer is a reason that takes one reason that you originally have and reduces its impact, reduces its value. An example here again can clarify this matter, which is really very abstract. Let's say that we're trying to make a decision on whether it is the case or it's not the case that Mary was at the party. In principle, we have two reasons. We have a reason that counts against she being at the party, which is that we know that Mary does not like parties. On the other hand, we have the reason that A has made a testimony saying that yes, he saw that Mary was at the party. So we have again this sort of balance of reasons, which you see here in the horizontal red line and the horizontal blue line. But you could have an underminer, which is that we know that A is a habitual liar. A is the sort of person that lies very often and sometimes without a good reason. And then you can see this operating on your vectors in this manner. Now, the vector of force that was originally one against the other, completely opposed to each other, you could see it moving in the direction of the green arrow, getting it slanted upwards. And if you think of this in terms of physics, of the ability of a force to move an object, you will immediately see that it lessens the force. So the A's and habitual liar lessens the force of A's testimony. This, of course, is just a metaphor, but you will see it's a very useful metaphor, at least if you like seeing these sorts of issues visually. And I will keep on with this metaphor because, yeah, at least I find it useful, and I hope you will also find it useful. I'm not the first person either to really use a sort of vectors metaphor for reasons. So let's keep going. Now, in addition to that, you will also have other scenarios where instead of the second order reason simply undermining the first order reason, it completely nullifies it. This is what I would call a defeater. Instead of just undermining the reason, instead of reducing its validity, it completely eliminates it. And here again, here I will give you an example that it's a little bit more legal, because as a matter of fact, legal reasons tend to be powerful enough to completely defeat, to completely exclude from validity other reasons. So here is in a scenario where we are trying to come to the conclusion of whether A is punishable or not punishable. And then, well, reason in favor of punishing A, he stole my TV. Reasons against this, he had a bad upbringing. But the reason that he stole my TV gets completely nullified once we discover that A is a minor. Minors are not subject to criminal punishment. There you can see that the green arrow moves the vector of force, but it moves the vector of force in such a way that it makes it completely orthogonal to the question about to the question of whether A is punishable or not punishable. And then in this maneuver, you say it reduces its effect, its practical effect, to zero. Now, A stole my TV. Once we discover that it's a minor, becomes orthogonal, gets up, it becomes this vertical arrow, and that makes absolutely zero contribution to moving in the rightward direction. Having now presented some of the ground that's just about reasons and reasoning, we're going to move to rights specifically. And really, I think this is the right way of doing it. Legal reasoning cannot be a special type of reasoning. Legal reasoning is just informal reasoning, informal logic applied to a specific domain. So, to begin to understand legal reasoning, we cannot do otherwise than begin with reasoning generally. So let's say something about rights specifically. So here we have again our diagram, and our diagram, again, at least to me, shows itself to be very useful. Imagine you are trying to decide whether to honor the right or honor other considerations of policy, considerations of economics, considerations of culture. Well, typically, the notion is that rights are trumps. So this is how Ronald Dworkin characterized rights, like trump cards in a game of card. When you put the trump card down, you immediately win. So the idea then would be that if a right is in the picture, the other considerations, follow the green arrow. They get orthogonalized. They are rendered, they're defeated, they're excluded, they're rendered useless. They make no force into moving the decision anyways to the left. So that is, just to get started, a basic idea of the function of rights. Rights are special, and in the game of reasoning, they would normally play the role of these defeaters that simply take out, exclude consideration of just other things that we might want to take into account normally. However, dworking is not 100% right. And you already know this. You already know this because you studied the law already for 5, 6 weeks. And you know that the reality is that rights are not always trumps. In international jurisprudence, it's generally accepted that when certain conditions are met, rights can be limited. And in fact, they can even end up getting defeated by the public interest. Now, and then let's say that we have two gatekeeping conditions. First, that the limitation must serve as a legitimate aim, and second, that the limitation must be provided by law. Once those two elements get clicked, you can imagine then that the red arrow will move from this orthogonal position where it has no contribution to moving things leftwards. It will move down to some degree, to some extent, and that will be controlled by, let's say, considerations of proportionality. That's a matter of degree. Due to considerations of proportionality, the right may move, let's say, in angle more and more and more. Pardon, the consideration of the public interest may move in angle more and more and more as to oppose the idea of the right. Then it would be to eventually be able to completely counter it. Of course, if it's in certain diagonal, you could see that the force is going to be less. The force that it has to move the decision all the way to the other side. But then that depends on proportionality. And then public interest considerations can be opposed to rights if certain conditions are met with different degrees of intensity. In addition to this scenario of rights getting limited for the public interest, we have a different scenario that's, let's say, simpler, more difficult, and more interesting, which is the scenario of conflict of rights. Here in conflict of rights is the image that you see right here. Now, you have on the one hand the reason that a right is applicable, let's say right X is applicable, then you that would plead for the conclusion of honoring right X, but you also have the reality that right Y is applicable, which would plead to the conclusion of honoring right Y. And then it seems that then nothing is at angles. You simply have here opposing considerations, and you are left free to decide which of the rights is more powerful, which of the rights is stronger. And what you see here essentially, and the reason I find this image here very useful, is that you see that here we are essentially going all the way back up to our umbrella example. It's just the unencumbered decision between one and the other. How important is this one? How important is the other one? Without all these other considerations that may reduce or diminish the force of a right. And this says a lot about why conflicts of rights are problematic. When you have conflicts of rights, the law seems to really no longer be governing the type of reasoning that you're doing. So you fall back into the normal type of reasoning in moving from the reasons you have to an all things considered judgment, just weighting the considerations that appear to you. And then it's let's say you end up in a very free scenario where you just have to decide whether right Y, let's say non-discrimination, is more important than right X, freedom of speech. There might be some ways to enrich the discussion of conflict of rights. And one of them has to do with the theory of abuse of rights. The theory of abuse of rights is not one that is officially or widely recognized, but there are cases where the decision of the court seems to be best explained as one that has to do with abuse of rights. And essentially, abuse of rights would mean that if you have right Y versus right X, but then the way right Y is being used is actually abusive, you can somehow move move the red arrow in this case up a diagonal, and then reduce its effect in the push and pull of forces. Well, a right that is abused is still a right, but to the degree that it is abused, it's less desirable to honor it. It's less desirable to protect it. Then, for example, there is a very classic case of the European Commission of Human Rights. So that is before the European Court of Human Rights became the sole actor and eliminated the Commission. Now, there's a case decided in the European Court of Human Rights about a certain form of hate speech, certain form of undesirable of speech that had the aim of destroying the rights and freedoms found in the European Convention of Human Rights. And then that was one of instead of simply saying, okay, well, we have this right versus the public interest, or we have this right versus non-discrimination, instead of just making this sort of comparison of one side against the other, what the commission did is that it noted that the use that was being made of free speech was abusive, because well, it's like figuratively is like sawing the branch in which you are sitting. So you're using the freedoms, let's say the freedom of speech, to destroy the system of rights and freedoms. then that would be, let's say, a very paradigmatic example of an abuse of a right. And the idea would be that in a scenario such as that, you would want to say that instead of the rights really facing each other, just one side to side, one of them gets diagonalized, and therefore its impact in the push and pull of forces becomes lessened. And see, this diagram, it may be intuitive for some of you, it might be counterintuitive for many of you, but it's really very useful. It's very, very applicable. Because, for example, another thing that we could model here, and I think we already have done enough models, is that rights can actually be defeated. That is orthogonalized. That, let's say, put completely vertical, and then they would count for zero. For example, when a right has an exception, or for example, when the right gets completely derogated in a state of an emergency. Say, well, you have a right to freedom of expression, but we're in a civil war. Maybe then the right gets derogated. Maybe it counts for zero. Now, international jurisprudence does not really accept that. International jurisprudence will say it's not really zero. It still casts a shadow, but okay, that is debatable. The point is that the model can be used to explain also these sorts of phenomena. And these are phenomena or for which I will not speak much because we have already discussed them, already covered them in the context of the course. So now let me raise a third issue. So we first issue is just reasons and reasoning. Uh, then you have second order reasons which impact first order reasons, and we applied them to rights. But now the third order question in the game of reason is essentially who should be doing this operation. Now, it's quite common for people to say, well, that's what judges do. The job of judges is to decide particular cases and then to weigh the reasons in favor of a conclusion and against a conclusion in that particular case. And judges have the independence and they have the impartiality and they have the training to be able to do it. That is a very common position. And you could add to that also that judges are the natural protectors of minorities, because then judges would be able to hear you as an individual as opposed to the democratic game in which the biggest is going to be the winner. But there is also a powerful countercurrent to this that says that if the game is going to be balancing, the ones that are most able to do it are not judges but legislators. So if really you're ending in a situation as the one described here, where you have just the red and blue arrows completely opposed to each other, and this let's call this just a dilemmatic case where you have one right and another, and there's no contribution of a purely legal principle. So you're back, let's say, just deciding whether to bring your umbrella out or not, that you have a decision of this sort, that it's really a decision that's unconstrained by law, and then it's more legitimate that the decision gets taken by a legislative body which represents the population. And then you could also say, of course, that the experiences of judges, however good or noble they may be, are really very limited. Judges are a very narrow elite. Then Parliament, as a more representative body, will have more insight into whether you really want a society with more equality or with more freedom, or whether you want, let's say, to take a very horrible measure and shoot down a plane in the case of the Civil Aviation Act, or if you want to say, well, no, we allow the terrorists to fulfill their plot, but we will never raise our hands against innocent lives. So these, of course, are really dilemmatic cases. And you could say, well, all things being equal, maybe it's parliaments the one that have the greater information to be able to take wise decisions on this matter. And then, of course, you say, well, judges as natural protectors of minority. The data on this seems to me inconclusive. Well, there's cases where this has been true, and there's also been cases where it hasn't. So this is the topic for today. This is a little bit maybe of a different lecture. It's a very abstract one. I hope it still appears to be useful, and of course, the benefit of doing it in this way is that you will have access to this file, which has mistakes, which I have just noted right now. So yeah, I hope you find this useful and an addition to your materials.